And conversations around the latest round of executive orders signed by President Donald Trump have led to growing misinformation issues. One action that has many talking is the potential impacts to the Equal Employment Opportunity Act. CBS News Detroit's Elaine Rojas Castillo is on your block in Midtown with a breakdown of the confusion and what you need to know.
This executive order does not have the power to override laws that we already have on the books that are passed by our legislature.
On Tuesday, President Donald Trump signed a series of executive orders eliminating diversity, equity, and inclusion, or DEI, government programs, with a memo going out to federal agencies placing all DEI office staffers on paid leave immediately.
Okay, so the legal walls are closing in on Trump's mass firing spree, and this one is different from all the others. This isn't just about procedural violations or shutdown rules or whether the administration followed the right steps when they fired people. This one goes straight to the heart of something much bigger: discrimination. On December 3rd, 4 federal workers who were fired from DEI-focused roles at major government agencies walked into a federal courthouse in Washington, D.C., and filed a proposed class action lawsuit that could end up representing thousands of workers who were targeted and terminated for the same reasons. They're saying Trump's executive orders didn't just break civil service rules. They're saying these orders were discriminatory purges that violated the First Amendment and federal anti-discrimination laws. They're saying workers were fired not because of their job performance, not because their positions were unnecessary, but because they supported programs that help marginalized communities. And that's illegal. That's not just bad policy or government overreach. That's discrimination, and there are laws against it. But before we go any further, real quick, let's be honest. You can't really trust mainstream media anymore. That's why we built Pump Politics, to bring you real stories, real context, and no corporate spin. If you want to stay ahead of the headlines, join our free newsletter. We'll send the news straight to your inbox every day. Just click the link in the description to join. And if you just want to support what we're doing, join us, be part of the community that actually cares about the truth. All right, let's get back to the video.
65. It does not get rid of the larger Equal Employment Opportunity Act that was part of the Equal Rights Amendment.
This will have zero effect, no effect whatsoever on my ability to protect those people out there who've been discriminated against.
Marco says people should remain calm and remember that an executive order may have the power to make some changes, but there are state laws in place to block or limit any immediate impacts.
Our laws that we have in Michigan and federally that give you access to these protections are enshrined from our Constitution, and President Trump can't touch those. No president can touch those. Those are in our Constitution, and they're in our laws that are passed by our elected representatives.
Elaine Rojas Castillo, CBS News Detroit.
Think about what this means for a second. We've been watching all these legal battles over federal layoffs, and most of them have focused on process. Did the administration follow the right procedures? Did they violate the shutdown moratorium on reductions in force? Did they give workers proper notice? Those are important questions, but they're ultimately about paperwork and bureaucratic rules. This lawsuit is saying something much more serious. It's saying the Trump administration deliberately targeted workers based on their perceived political views and their association with programs serving minorities, women, LGBTQ individuals, and other protected groups. That's a whole different ballgame legally. That's the kind of allegation that can result in not just reinstatement, but actual damages. That's the kind of case that can expose a pattern of intentional discrimination that affects how courts view everything else the administration is doing with federal workers. The plaintiffs in this case worked at agencies across the government: Department of Homeland Security, Department of Justice, National Institutes of Health, Office of Personnel Management. These aren't fringe positions at obscure agencies. These are major departments at the center of how the federal government operates. And the lawsuit is targeting more than 20 agencies total, arguing that the discrimination was systematic and widespread. The attorneys representing these workers aren't mincing words either. They said straight up that dismissing nonpartisan federal employees based on their perceived political views violates these workers' constitutional and legal rights. That's a direct challenge to the entire premise of what the administration has been doing. They've been claiming these layoffs are about efficiency and cutting waste. This lawsuit says no, they're about politics and discrimination, and we can prove it. And here's the thing that makes this lawsuit particularly significant. It's a proposed class action. That means if the court certifies the class, It won't just be about these 4 individual plaintiffs. It could represent thousands of workers who were fired under similar circumstances for similar reasons. The scope of potential liability here is enormous. We're talking about back pay for thousands of people. We're talking about potential damages for discrimination. We're talking about a court potentially finding that the administration engaged in a systematic pattern of illegal conduct. That's the kind of ruling that doesn't just affect the workers directly involved. It affects the administration's entire approach to workforce reduction, and it creates precedent that constrains what they can do going forward. So we're going to dig into exactly what this lawsuit alleges, why it's different from the other legal challenges we've seen, and what it means for the broader fight over Trump's federal workforce overhaul. Because this one could be a real game changer. Stick around. All right, so let's really get into what this lawsuit is alleging and why it represents such a serious legal threat to the administration's entire approach to federal workforce reduction. Because the details here matter, and they paint a picture of something much more troubling than just overzealous cost-cutting or poorly executed layoffs. The 4 named plaintiffs in this case are federal workers who had one thing in common. They worked in roles connected to diversity, equity, and inclusion programs at their respective agencies. One worked at the Department of Homeland Security, one at the Department of Justice, one at the National Institutes of Health, one at the Office of Personnel Management. Different agencies, different specific jobs, but all connected to DEI initiatives in some way. And they were all fired as part of Trump's executive orders targeting these programs. Now, the administration's position on DEI has been clear from the beginning of Trump's second term. They view these programs as wasteful at best and as ideological indoctrination at worst. Trump signed executive orders specifically targeting DEI initiatives across the federal government, ordering agencies to eliminate these programs and terminate the employees associated with them. From the administration's perspective, this is just good governance, getting rid of programs they see as unnecessary and the positions that support them. But the lawsuit argues that what looks like policy disagreement is actually something much more sinister. They're saying these terminations weren't really about the programs at all. They were about punishing workers for their perceived political views and their association with efforts to support marginalized communities. And that kind of targeting violates both the First Amendment and federal anti-discrimination laws. Let's break down the legal theories here because they're important for understanding why this case is different from the procedural challenges we've seen in other federal layoff cases. First, there's the First Amendment claim. The Constitution protects federal workers from being fired based on their political beliefs or associations. The government can't just terminate employees because it disagrees with their politics. There's a long line of Supreme Court cases establishing that public employees have First Amendment rights that protect them from politically motivated terminations. The lawsuit argues that's exactly what happened here. Workers were targeted not because of anything wrong with their job performance, but because the administration associated them with political views it opposes. Supporting diversity initiatives in the administration's eyes apparently makes you a political enemy who deserves to lose your job. That's not a legitimate basis for firing someone under the Constitution. Second, there are the civil service law violations. Federal employment law includes extensive protections designed to ensure that hiring and firing decisions are based on merit rather than politics. These protections exist precisely because we learned from history that when employment decisions become political, you end up with a corrupt and incompetent government workforce where loyalty to the party in power matters more than actually doing your job well. The lawsuit argues that the DEI firings violated these merit system principles by targeting workers based on political considerations rather than legitimate performance or efficiency concerns. That's a serious allegation because it strikes at the foundation of the professional civil service that's supposed to be insulated from political interference. Third, and this is where it gets really significant, there are the anti-discrimination claims. The lawsuit alleges that the DEI firings had a disproportionate impact on people of color, women, and non-binary persons. That's not an accident. DEI programs, by their nature, tend to employ and serve people from underrepresented groups. When you target those programs for elimination and fire everyone associated with them, you're inevitably going to be firing a workforce that is disproportionately composed of minorities and women. The lawsuit argues this constitutes illegal discrimination under federal workplace laws that prohibit employment actions with discriminatory effects, even when there's no explicit intent to discriminate. This is what lawyers call disparate impact discrimination, and it's illegal under Title VII and other federal statutes. Now the administration would obviously dispute all of these characterizations. They would say they were eliminating programs, not targeting people. They would say any employee whose position was eliminated was offered opportunities to transfer to other roles. They would say the decision to end DEI programs was a legitimate policy choice that the president has authority to make. They would deny any discriminatory intent and argue that any disparate impact was an incidental result of ending programs that happened to employ certain demographics rather than a deliberate effort to discriminate. These are the kinds of arguments that will play out in court over potentially years of litigation. But the fact that these claims are now being made in a formal legal proceeding with the potential to become a class action representing thousands of affected workers puts enormous pressure on the administration. And here's something important about the procedural posture of this case. The lawsuit mentions that a prior claim was dismissed by the Merit Systems Protection Board back in July 2025. The MSPB is the administrative body that handles a lot of federal employment disputes, and it apparently didn't find merit in an earlier version of these claims. But now the plaintiffs are escalating by going directly to federal court with a class action that potentially covers thousands of workers. That's a different venue with different procedural rules and potentially different outcomes. Federal judges have lifetime appointments and don't answer to the administration the way executive branch agencies do. A federal court class action is a much more serious threat than an administrative complaint, and the administration's lawyers know it. The scope of this lawsuit is genuinely staggering when you think about the numbers involved. The plaintiffs' attorneys are targeting more than 20 federal agencies where DEI-related firings occurred. They're seeking to represent potentially thousands of workers who were terminated under similar circumstances. If the class gets certified and the plaintiffs ultimately prevail, we're talking about massive liability for the federal government. Back pay for thousands of workers over potentially years of unemployment, possible compensatory damages for the harm caused by discriminatory terminations, injunctive relief ordering the administration to stop the discriminatory conduct and potentially reinstate fired workers. The legal exposure here is enormous, and it's going to require significant resources to defend against, resources that could otherwise be going toward actually running the government. This lawsuit also connects to the broader pattern of legal challenges we've been tracking throughout Trump's second-term workforce reduction efforts. Judge Susan Ilston's rulings blocking layoffs and calling the administration's approach fire then aim. The Supreme Court ruling that lifted some injunctions but didn't resolve all the underlying legal questions. The ongoing battles over shutdown-related layoffs at the State Department and other agencies. Each of these cases is fighting on slightly different legal terrain, but they're all part of the same fundamental conflict between an administration determined to dramatically shrink the federal workforce as fast as possible and workers and unions fighting to preserve their jobs and enforce the legal protections that are supposed to govern how the government treats its employees. This DEI discrimination lawsuit adds another front to that war, and it's potentially the most dangerous one for the administration because discrimination findings carry consequences that go beyond just this particular set of firings. So let's break this down into what you really need to understand about this lawsuit and what it means for the ongoing battle over Trump's federal workforce overhaul, because this case has the potential to reshape how courts view everything the administration has been doing and to impose real accountability for what plaintiffs are alleging was systematic discrimination against federal workers. First point. The discrimination angle is fundamentally different from the procedural challenges we've seen in other cases and potentially much more damaging to the administration. When courts have blocked layoffs based on procedural violations like the shutdown moratorium or improper RIF procedures, the remedy is usually pretty limited. The administration fixes the procedural problem and tries again. Workers might get temporary relief, but the underlying authority to conduct layoffs isn't really questioned. Discrimination is different. If courts find that the administration engaged in discriminatory conduct, that's not something you can fix with better paperwork. That's a finding that the government violated people's constitutional and statutory rights. That comes with damages, that comes with injunctions, that comes with a stain on the administration's record that affects how courts view their credibility in other cases. That's why the administration should be very worried about this lawsuit, even if they've successfully fended off some of the procedural challenges. The First Amendment claims are particularly significant because they go to the heart of what kind of government we want to have. Do we want a professional civil service where people are hired and fired based on their ability to do the job? Or do we want a political spoil system where your employment depends on whether you agree with whoever happens to be president at the moment? The civil service reforms of the late 1800s and early 1900s were specifically designed to move us away from the spoils system toward a merit-based professional bureaucracy. Those reforms exist because we learned through painful experience that politicized government employment leads to corruption, incompetence, and instability. When the lawsuit alleges that workers were fired for their perceived political views, it's alleging that the administration is dragging us back toward the bad old days of patronage politics. Courts take that seriously because the constitutional and statutory framework protecting federal employees from political retaliation exists precisely to prevent this kind of abuse. Second point, the class action aspect of this lawsuit multiplies the stakes exponentially. Individual lawsuits by fired workers can be important, but they're limited in scope and impact. Each case is about one person's termination, and even if the plaintiff wins, the remedy is limited to that individual situation. Class actions are different because they aggregate claims across potentially thousands of affected workers into a single proceeding. If this class gets certified, and that's a significant procedural hurdle the plaintiffs will have to clear, then the case becomes about a pattern of conduct affecting everyone in the class. Discovery will be broader. The evidence will paint a picture of systematic behavior rather than isolated incidents. And if the plaintiffs win, the remedy will have to address the harm done to the entire class, not just the 4 named plaintiffs. The administration's lawyers understand this, which is why they're going to fight hard against class certification. They'll argue that each firing decision was individualized and based on the specific circumstances of each position and each employee. They'll say you can't lump thousands of different workers at dozens of different agencies into a single class because their situations are too different. Whether that argument succeeds will depend on whether the plaintiffs can show sufficient commonality in how the decisions were made and what motivated them. If they can point to the executive orders themselves as the driving force behind all the terminations, and if they can show that the same discriminatory logic infected decisions across agencies, they have a good argument for class certification. This procedural battle over class status might ultimately determine whether this lawsuit is a minor irritant for the administration or an existential threat to their workforce reduction agenda. Third point, this lawsuit exposes the tension at the heart of the administration's DEI offensive and forces them to defend their actions in a forum where political rhetoric doesn't carry much weight. In the political arena, the administration has been able to attack DEI programs as woke ideology and government waste without really having to justify those characterizations with evidence. Their base cheers when Trump talks about eliminating these programs, and they don't need to prove anything to win political points. But court is different. In court, you have to actually demonstrate that your actions were lawful and based on legitimate government interests. You can't just wave your hands and say DEI bad. You have to explain what specific legitimate purpose was served by terminating each worker. You have to defend the process you used. You have to respond to evidence that your stated justifications were pretextual and that the real motivation was political or discriminatory. The plaintiff's lawyers are going to be very interested in discovery, the legal process, where each side can demand documents and testimony from the other side. They're going to want to see internal communications about how the DEI firings were decided. They're going to want to know what criteria were used to identify workers for termination. They're going to want testimony from the officials who made these decisions about what they were thinking and why they made the choices they made. If there are emails or memos that show political considerations driving the decisions, that's going to come out in discovery. If there's evidence that workers were targeted for their perceived views rather than for legitimate efficiency reasons, that's going to come out too. Discovery is where lawsuits often become really dangerous for defendants because it forces transparency about decision-making processes that officials would rather keep hidden. The administration might find that their internal communications don't look as good in a courtroom as their public statements sounded at press conferences. Fourth point, this lawsuit is part of a broader legal strategy by unions and worker advocates that's designed to create multiple pressure points on the administration simultaneously. You've got the procedural challenges to RIFs during the shutdown. You've got the constitutional challenges to Trump's executive authority over the workforce. You've got the First Amendment claims about political retaliation. You've got the anti-discrimination claims about disparate impact on protected groups. Each of these legal theories operates somewhat independently and requires the administration to defend on multiple fronts at once. Even if they win some cases, losses in others can still impose real constraints on what they can do. And the cumulative effect of fighting all these battles simultaneously is to slow down the workforce reduction machine, impose costs in terms of legal resources and management attention, and create uncertainty about which firings will ultimately be allowed to stand. That uncertainty itself has value for workers because it makes the administration think twice before proceeding with terminations that might end up being reversed by courts. So where does this leave us? We've got a major new lawsuit that attacks the administration's DEI firings as discriminatory rather than just procedurally improper. We've got plaintiffs seeking to represent potentially thousands of affected workers across more than 20 federal agencies. We've got legal theories that could result in significant damages and injunctive relief if they succeed. We've got an administration that's going to have to defend its decision-making process in discovery, where the truth about their motivations might look very different from their public justifications. And we've got yet another front opening up in the legal war over federal workforce reduction at a time when the administration was probably hoping the Supreme Court ruling had settled things in their favor. This lawsuit reminds us that legal battles aren't decided by a single case or a single ruling. They're decided through a long process of litigation across multiple venues with multiple theories and multiple potential outcomes. The administration won a big victory at the Supreme Court, but that doesn't mean they've won the war. Every time they fire someone for arguably discriminatory reasons, they create potential liability. Every time they target workers for political reasons, they risk First Amendment violations. Every time they move too fast and too carelessly, they give plaintiffs' lawyers ammunition to use against them. The DEI lawsuit is the latest salvo in this ongoing battle, and it won't be the last. Keep watching, because this fight is going to continue for years, and the outcome is going to shape what kind of federal government we have and what kind of protections federal workers can count on. Stay tuned.